Good morning. We're just giving folks a couple minutes to join and then we'll get started. If you're just joining us, we're just giving folks a minute or so to join and then we will jump into the webinar. Looks like that has slowed down, so we'll go ahead and get started while folks continue to join, get through some housekeeping items. So good morning, everyone. Thank you for joining us. This is our webinar on CEQA and how it can impact your wildfire risk reduction efforts. My name is Melissa Keene, Director of Enterprise Programs and Special Projects at ILG, and I will be your host and moderator for today's conversation. So a quick overview of what we're going to do today. As I mentioned, we're just going to start with a quick welcome and some housekeeping items, and then we're going to hear from two experts in the field who are going to present some information on CEQA and how that is going to impact wildfire efforts. And then we will have time for audience Q&A, and then we will wrap up and adjourn by 12:30. In terms of tech and housekeeping, as you joined, you probably noticed that you're muted. You will be on mute for the duration of today's webinar, but that doesn't mean you can't ask us questions. So you should see a Q&A box at the bottom of your screen. Please feel free to drop any questions in there during the course of today's webinar, and we will get to as many as we can during the Q&A portion at the end of the session. You also probably noticed we are recording, so we will be recording the full session, and that recording will be posted and sent out to all of you along with the slide deck following today's webinar. So stay tuned for that in the next week or so. Before we jump in, just want to share a little bit of information about ILG in case you aren't familiar with us. We are a nonprofit, nonpartisan, statewide organization affiliated with the League of California Cities. We were founded 70 years ago, and our mission is to serve and support local governments, including the over 2,500 cities, counties, and special districts in California. We provide practical and easy to use resources so that you all as local agency leaders can more effectively implement policies on the ground. We do this in a number of ways. We do a lot of education and training, such as today's webinar, conference sessions, etc. But we also provide technical assistance, capacity building, and convening services for agencies statewide. We have four main focus areas. Today's conversation is related to our sustainable and resilient communities pillar and how agencies can be more proactive in that space and think about land use decisions and all of those types of things that impact how resilient our communities are in wildfire and other emergencies. But we also have programs focused on public engagement, workforce development and civics education, and leadership and governance. So if you aren't familiar with us, definitely encourage you to go to our website. We have a lot of free resources, free trainings available to you all as local agencies. As a reminder, in case you haven't joined us for other sessions, this conversation is part of a four-part series of webinars that we started last fall. So you see the other three conversations that we had on the screen there. All three of those webinars have been archived on our website, so you can access those recordings, access those slide decks, speaker information, etc. if you weren't joining or if you want to go back and revisit any one of those sessions. A lot of great information. We just realized that this was too big of a conversation to have in one session, so we broke it up into a number of different conversations over the last few months. So definitely encourage you to take a look at those if you have not already. And with that, I want to introduce our two speakers for today's conversation. So I'm joined by Dave Winnacker, who has been a component of all of our webinars up to this point. He's a retired fire chief and a consultant for ILG's partner Renee Public Management Group. And I'm also joined by Kathryn Oehlschlager, who's a partner at Stoel Rives and an expert in the CEQA space and can help us navigate some of these conversations as it relates to the intersection of CEQA and wildfire. So with that, I'm going to stop my share so that Dave can take over and get us started in this conversation.
All right. Thank you very much. I appreciate the opportunity to talk about wildfire risk reduction. As a reminder, this webinar builds upon our previous discussions about how to design a program, how to value the different approaches to wildfire risk reduction, really focusing on how to track progress. The intent of today, we happen to have a true expert on this topic, is to demystify CEQA and to help the participants in this webinar and those of you who are doing this in the public agency space to understand both how you successfully navigate CEQA requirements, how you weigh the impact CEQA could have on a project to select the appropriate CEQA compliance mechanism, and to help us all move beyond a space where someone says environmental without any backing or justification behind that, and that shuts a project down, either internally, where there's a sense that it's too hard because there are environmental considerations, or externally, where residents or other third parties say there are environmental concerns, and that becomes the end of the conversation. So to get us started, I'll quickly walk us through a review of what we talked about before, noting that for the purpose of the conversation today and this webinar series, what we're looking at exclusively is wildfire risk to communities, to the built environment. So there is a separate and important but separate discussion about fire return intervals and balancing large natural landscapes. But what we're looking at today and in this series specifically is the risk of a wildfire initiated urban conflagration. So a wildfire threatening a single isolated home on, say, a couple acre ranchette somewhere or in a rural setting, we know what needs to be done for that. Defensible space and home hardening. It's been state law since 1967. It's clearly understood how to effectively prepare those homes for fire. What is less clearly understood and is a more recent phenomenon is when we have wildfire that transitions into the built environment and subsequently spreads in a structure to structure manner, where the primary fuel carrying the fire from a modeling standpoint are structures themselves. And structures produce sufficient flux, the watts per meter squared over time, that a structure that is within 10 meters of another structure will ignite structure B, irregardless of the presence of wildfire specific mitigations, because it's now an urban fire. So, with that, let me walk you through a quick review. So, what we're looking at is a time and a place where we have sustained strong winds, we have low relative humidity, and we have highly receptive vegetative fuels. So, something in a Mediterranean county, say in California, where we're talking about the fall or late fall, where we are months removed from the last measurable rainfall. The vegetative fuels have gone dormant and are thoroughly dried out, both the live and dead fuels. And then we have a strong low relative humidity wind event. So, given those preconditions and an ignition, we will see rapid fire spread through vegetation. That's simply the way things occur. And where there are alignment between topography, fuel, and weather, that fire spread will be particularly fast, right? So we're talking funneling conditions around topography, which is causing a Venturi effect to achieve higher wind speeds. Places where the wind and the slope are in alignment, where we have fuels capable of carrying a fast-moving fire, i.e. grass and brush, as opposed to timber, we can see rapid fire spread. And when that rapid fire spread encounters the built environment at a point of entry, and there are vulnerable structures, i.e., structures that are not prepared to receive fire, both ground component fire, where the preparation is defensible space and home hardening, or three-dimensional ember cast, where the preparation, the mitigation is a Class A roof, ember resistant vents, and zone zero that would make that home resistive to three-dimensional ember attack. When fire encounters the built environment and there are sufficient vulnerabilities at the point of entry, we can begin to see structural ignitions at a pace that outruns our firefighting response. Or put more simply, there is more fire than firefighters at the time and place where fire is transitioning in the built environment. And when that occurs, where we have contiguous, tightly spaced structures, i.e., structures with sufficient density that they will support sustained structure to structure spread, and we have outpaced our firefighting response such that it becomes overwhelmed and is ineffective, as outlined in Jack Cohn's WUI disaster sequence, we have the conditions that can initiate and sustain urban fire spread. And that's really the phenomenon we have been responding to in the last 10 or so years now, as fire moves out of being a rural um, forested landscape space into something that is now affecting our built environment, our urban communities. So what that would look like here in a simple visualization, we have fire spreading from left to right across the landscape. Where that fire encounters the built environment, we have a point of transition for both ground component and embers. And beyond that point of transition, we also have an ember deposition zone where we have embers impacting downwind structures that can ignite homes, that can then start to ignite other homes, that can then spread into structure to structure urban fire. Here's a more simplistic view of that by phase. So we have ground fire burning through vegetation. That ground fire is also producing embers. As those embers land within the community, where they find receptive fuel beds, they can ignite structures. Where the ground fire encounters vulnerable structures, they can ignite structure fire. And those structures, as they begin to burn, they generate embers of their own that can further propagate the fire across non-burnable features like the road that's shown here. And then where those embers land and ignite either homes or the landscaping around homes, those can begin to burn other homes. And we can quickly get into a setting where we now have structure to structure ignition spreading from structure to structure, from structure caused embers to structures, and from structures to vegetation to structures, where we have interior islands, which then produce more embers. And this quickly becomes a self-sustaining reaction that can outpace any firefighting response. And this fire will now burn until either the wind stops, it runs out of structures, or it meets the ocean. And we've seen that several times, unfortunately. And of note here, these are the fires that we're responding to with regard to structure loss. And only 4 fires over the last 20 years have resulted in 50% of the structures. And why 40,000 structures lost over 20 years would be a true tragedy. It would not be nearly as bad, but for those 4 fires that got into dense structures and ran structure to structure in a manner that not only produced a great number of structures destroyed, but it also is essentially unstoppable once it has begun. And so our discussion then is about how we can interrupt that transition and what are the available tools and the systems within CEQA that will allow us to carry out the various forms of mitigation. So with that, I will hand it over to Kathryn, who is a true expert on this front, to walk us through CEQA Primer.
Great. Thank you, Dave. And first, I want to thank ILG and Chief Winnacker for having me. Really an interesting subject and something that has become very central to those of us who practice in land use and planning law. Wildfire is just a fascinating subject. And like many of you, I think I've learned a lot more from Chief Winnacker than anyone else. He's a fount of knowledge on this stuff. So given the group here, I'm sure some of you know CEQA like it's the back of your hand. Others probably encounter it, but maybe don't deal with it on a day-to-day basis. So I'm going to talk a little bit about the history of the law, what it does, what it means, so that we can then talk about how it applies here and strategies that you can employ as a local government to try to get important work done to address wildfire risk. CEQA was signed in 1970 by Governor Reagan. It is based on NEPA, the National Environmental Policy Act, which is, of course, the federal law that requires environmental review before a federal decision. CEQA is what we call a little NEPA or a mini NEPA, which is the state equivalent. It requires environmental review before state and local governments make decisions. Total side note here, but if you don't work in environmental law, you may not know that the Nixon administration had by far the biggest effect on environmental law of any administration in history. Not only did he sign NEPA, he created the EPA, he signed the Clean Air Act, Marine Mammal Protection Act, the ESA. So tells you something about how different government was in the late 60s and early 70s. But there are 2 sources of law that constitute CEQA, and this will become important as we talk about this. One is the statute, the law itself, that is passed by the legislature. That's in the Public Resources Code. And then the other is the CEQA guidelines, which is not statutory, but regulatory law that is promulgated by what we used to call OPR, but is now the Office of Land Use and Climate Innovation. Doesn't really roll off the tongue. That's a newish name for the agency, but they put out the CEQA guidelines. And those 2 things work together to tell you as an agency what you're required to do. Next slide. So the purpose of CEQA, I'm not going to walk through these bullets, but this is what the state says it's for. These are all good things, right? To prevent avoidable environmental damage to make sure that decision makers and the public understand potential environmental effects of proposed activities. So CEQA is important. It was passed for very laudable reasons, and it does serve an important function in our government. But for folks who work in government, you know, it also can be difficult to comply with and has presented some problems over the years. Next slide, please. And that's mostly in the context of CEQA litigation. So I say this all the time, and I have no confirmation that it's true, but I absolutely believe it. I believe that CEQA is the most litigated environmental law in the country. It, in a typical year, will produce between 20 and 40 published appellate decisions. That's a very big number for one subject matter area to produce that much new law. And that's hundreds and thousands of lawsuits being filed. That's just published appellate opinions. Each one of those ostensibly tells you something different and new about how you are supposed to comply with CEQA. So it's something that's difficult to track, is constantly changing. And part of the reason there is so much litigation is that it's a citizen enforced statute. There's no agency that enforces CEQA. Any individual essentially can file a CEQA lawsuit. And if they win that lawsuit, they can potentially recover their attorney's fees under the Code of Civil Procedure, which is a pretty appealing option for lawyers, and sometimes even more than the fees that they have spent. So it has become something of a cottage industry. And I put up just a couple of links here. A contemporary of mine, Jennifer Hernandez at Holland and Knight, writes a lot on the subject of CEQA abuse and how it has gotten in the way of important development in California. She really focuses on housing, but it's something that's fairly widely acknowledged that while this law does play an important role, it also has been abused in certain contexts. And so this is just, if you want to kind of wonk out on CEQA, a couple of things you could read. They're really interesting articles. Next slide, please.
If I may, Kathryn, just a tiny piece of color. As a former client of Kathryn's, when I was fire chief, two things really stuck in my mind as we were considering what posture to take in the face of threatened litigation regarding our wildfire risk reduction program. And the first one was Kathryn's brief summary, which is to say this is CEQA and that 50-50 is about as strong a case as you can have. And the second one was my board's concern about the potential that mounting a costly CEQA defense, which it is, had no certainty of success, no matter how strong the case, and then came with the liability for potential attorney's fees on the back end, and that the money that was potentially associated with that weighed very heavily on the board as we went back and forth about whether or not this was the hill to die on with regard to engaging in litigation, which is not something public agencies undertake lightly, but that was a very real consideration given that there was a degree of uncertainty no matter how strong the case.
Yeah, absolutely. And we talk about that a lot in CEQA, that there is, truly no way to absolutely bulletproof a CEQA document. And that's difficult advice to give a client or to inform a client of. But that said, we did win that case, and there are things you can do to shore up your CEQA determinations and kind of some best practices, which is a lot of what we're going to talk about in today's discussion. But first, I'm going to talk about some general concepts. So when does CEQA apply? CEQA is triggered by a project, which is any discretionary decision by an agency that may cause a physical change in the environment. So that's anything, right? A physical change in the environment could mean moving a lamppost 4 feet. So it applies incredibly broadly. Next slide, please. So once you've determined you have a project on your hands, and that could either be, again, the agency wanting to do something like a wildfire risk reduction project, or it could be a third-party application for a development project. Once you have a project under that definition, the first thing you need to ask yourself is your project exempt? And I can't tell you how often agencies forget to ask this question. You really need to have someone in your organization on your team who's familiar with the exemptions and can tell you whether or not you have an opportunity for one of them to apply. Because sometimes you might have a path to a much less onerous CEQA process than you might think. There are two groups of exemptions. Statutory exemptions are written, again, into the statute, into the law itself. Categorical exemptions, or CADXs, are established by regulation. There's one very important difference between these two. Statutory exemptions are not subject to exceptions, whereas categorical exemptions are. So there are exemption exceptions like if there are impacts involving a scenic highway, historic resources, and the one we litigate the most, which was at issue in the case that Chief Winnacker just discussed, the unusual circumstances exception, which says if your project presents unusual circumstances that lead to a potentially significant effect, then you can't rely on that exemption. So you can imagine that project opponents actually, use that a lot and make a lot of creative arguments that unusual circumstances exist. Next slide, please. So if you're not exempt, then you have to choose your CEQA approach, and that generally starts with an initial study. And that lays out, I think it's 20 areas that you ask the question, could the project have a significant effect on the environment? Those areas are things like, air quality, water quality, greenhouse gas emissions, and one is hazards, and wildfire comes into the mix on both the hazards discussion, and wildfire became its own category a few years ago as well. And those are laid out in Appendix G of the CEQA guidelines. And that initial study is supposed to tell you what type of document you're going to prepare for your project. If your initial study tells you that your project is going to have significant and unavoidable effects, you're required to do an environmental impact report. And by significant and unavoidable, that means effects that are significant under the thresholds in Appendix G, which tell us what significant means in each context. If they cannot be mitigated to a less than significant level, then they're significant and unavoidable. If you, on the other hand, can mitigate your impacts to a less than significant level through measures, or there are no potentially significant effects, you can do a negative declaration or a mitigated negative declaration. An EIR is a lot more work. There are public comment periods, there are required meetings, there's a draft, then there is a final EIR that has to have responses to comments received. It typically is going to take you a year or more. A negative declaration or MND is much faster. However, there's one very significant difference between these documents, which is that if you get into litigation, if you have prepared an EIR, the court is required to defer to the conclusions of the agency in that document. In other words, if somebody presents evidence that your project is, opposing your project, that your conclusions are wrong, the court's going to have to defer to the agency's conclusions. You sort of get, in a tie, the agency wins when it comes to the evidence. The opposite is true on a negative declaration. And so where you have a high-profile project or a controversial project, we often will advise clients to do an EIR, even though it's not technically required, because you will have that protection in litigation. Okay, next slide, please. Why is this relevant to wildfire risk reduction, fire prevention? Well, because CEQA is irritating and it can be a major undertaking and it is a lot of work. And agencies who are looking to undertake even very important projects may not have the wherewithal, may not have the resources, may not have the money to say we're going to go out and do an EIR, particularly in the face of opposition on biological issues. And that is what often comes up when we're talking about wildfire risk reduction. We're talking about landscape level changes, concerns about habitat, and that does deter action by agencies, even on very important projects. And then when those projects are undertaken, often they can be delayed due to litigation. So it can have a chilling effect on this type of work. As an agency, what can you do? I'm going to talk a little bit about a few different strategies and options for CEQA compliance to help move those projects forward without breaking the bank. Next slide, please. So we're going to move into exemptions, and these are some tools that you can use to approve these projects. So this is new. This is an exemption that was passed in 2025 and was specifically for wildfire risk reduction projects. I will tell you, I have done CEQA on a wide variety of large and small scale risk reduction projects, and it has really been the Wild West in court. UC Berkeley lost a big case in the trial court on its vegetation management program because the court said your project description was not significantly or was not adequately firm. You didn't have a specific project description. Well, that's because when you're doing vegetation management, you don't know exactly what you're going to need to do every year over a 20-year period, right? It's adaptive management. and they lost in the trial court on that issue. They ended up prevailing in the Court of Appeal, but that's just one of a number of cases raising these types of issues. These programs are very difficult to do adequate environmental review for, and they often get challenged by folks who have, biological concerns, potential pet issues about certain species, that sort of thing. So there have been a lot of cases. This is a great tool. And one thing that I want to point out about this tool is it's wildfire risk reduction projects, including, and then it gives you these as examples. It does not say limited to. So I think there is a lot of opportunity in this exemption to do things beyond what is specifically described in this exemption and still fit them within the wildfire risk reduction umbrella and take advantage of this exemption.
And if I may, Kathryn, I was involved in the several attempts that culminated in this legislation passing. Um, Two things just to offer as a caution. These were the activities that there was no pushback on. Everyone agreed, and they were easy to get put into the language. If you're doing things beyond these particular areas, the topic of concern that was regularly raised by environmental groups and others was all around mature trees. And so I would offer as a triple, quadruple click, whatever the greatest amount of attention could be called to something. Work that does not involve mature tree removal, i.e., is working either in the understory or is working in grass, and is not in southern coastal shrub or chaparral, is much easier to move forward with regard to having appropriate BMPs that can be followed, best management practices that can be followed, and a route to using this tool. I would just caution anything that involves mature tree removal is going to be highly scrutinized, and that was one of the things that resulted in this being a 4-year project to get this legislation enshrined, was concern that even along roadsides, this would become a backdoor to unpermitted logging.
Oh, that's really interesting. Um, but an important tool, and I think something that was overdue. So I'm glad you were able, despite it taking 4 years, to get that approved. A couple of other exemptions that relate to wildfire risk and could be used for these types of projects. This is minor alterations to land, which is exactly what it sounds like: minor public or private alterations in the condition of land, water, or vegetation that do not, to your point, involve removal of healthy, mature scenic trees. And it does specifically call out fuel management activities within 30 feet of structures to reduce the volume of flammable vegetation. And 100 feet of a structure with under certain circumstances. So this is, again, an opportunity to do some of the work that Chief Winnacker has been telling us is so important about fuel clearance.
Kathryn, could you speak briefly? Because I've seen agencies that have taken conflicting interpretations with regard to trees. From your perspective, is it healthy and mature and scenic? Is it or between those?
I don't know. It's an interesting question. I have never dealt with that with an agency. Um, Yeah, the way that it's written, I would interpret it to mean that it would have to meet all three, but it will depend. And most cities and counties have a tree ordinance, right? They have something in their own particular code that gets kind of looped into these discussions about what they require or how they limit tree removal. So it might need to be interpreted in the context of those laws as well.
Yeah, and I've seen both ways, and I've seen NOEs filed for both. I think it depends on the environment you're in. I would just caution, proceed with great care for anything that involves removing trees over about 8 inches DBH. You get into a very, very contentious space at that point.
Yeah, noted. Okay, so the next one I will talk about is, I think, actually an exemption that has not been, well, I shouldn't say that. I think it's not as directly applicable in terms of the verbiage, but it is something that is a tool in the toolbox of exempting these types of cases and these types of projects. It is also the primary exemption that we did rely upon in the case that Chief Winnacker talked about, and this is regulatory agencies for protection of the environment. I personally think it's a very defensible position to say that you are trying to protect, enhance, restore, and maintain the environment when you are trying to prevent it from burning down. And so regulatory actions as a regulatory body, which cities and counties and fire districts are, to take steps to ensure the, again, maintenance, restoration, or enhancement of a natural resource. We successfully defended this exemption applying to a wildfire risk reduction program at the Moraga-Orinda Fire District. Just quickly, the facts of that case. The MOFD had approved a program for vegetation management that was modeled after the state fire safe guidelines, essentially what had been done at the state level. And the state had actually used this exemption to approve it at the state level. And we then did the same. It was, from my perspective, fairly straightforward. It required some limbing of trees, spacing of bushes, but opponents in the area didn't like the fact that on larger parcels, and there are quite a few in this area, it would require essentially some fuel break type work at the edge of properties in fairly large swaths of land. And so they sued with concerns over, woodpeckers and, dead trees on the ground that they thought provided habitat. And we were successful in convincing the court that this exemption applied. This is a CADX, so there are exceptions. We also convinced the court that there were no unusual circumstances here or other exception that would apply to take us out of that exemption. So it was, from my perspective, a really big win. I did not put a slide up here on the emergency exemption, which was also part of that approval, and we also defended in court, which is a statutory exemption for essentially actions by the government to address emergency conditions, which I think is also something that's been less used, but was also part of this case. And Dave, I don't know if you wanted to comment at all on the litigation.
I will briefly. Thank you, Kathryn. So just for details, within the fire district, we had previously, due to concerns raised by another public agency, we had previously pulled both defensible space, that being exterior hazard abatement requirements within 100 feet of a structure supported by notice of exemption filed with the county clerk. We had pulled those out of the fire code and put them into a separate ordinance. We had further created an ordinance that required, for large parcels, required a perimeter fuel break of up to 100 feet, not a fire break. So we're not down to bare mineral soil, no bulldozers, no soil disturbance involved, but breaking up the continuity of fuels with an emphasis on removing dead fuels and spacing live fuels such that the large parcels within the fire district were compartmentalized. So that if fire began on one parcel, it would be delayed by those fuel modification areas on the perimeter fuel breaks. It would be delayed in transmitting onto adjacent parcels. And this was done for a number of reasons, but one was a recognition that those large parcels generally had poor access. We didn't have gridded streets, we had limited roads, we had limited ways to get into them. So that if a fire began in one of these large interior parcels, it is likely it would be able to build and spread and escape initial containment and then threaten the structures that surrounded that parcel. And this was an attempt to create a varied age class fuel mosaic similar to what would be seen in a fire-dependent landscape that was experiencing episodic fire in accordance with a natural regime. That was all part of the findings of fact. And a resident objected that we were not properly considering the cumulative effect of doing this work across a significant number of parcels within the fire district. Obviously, we prevailed, which was very helpful. And the point here was that one of the cases that we argued was that one, which I'll address in a later slide, there was an override through the modifications process, which has been part of the fire code for decades, that allowed a resident who felt that our requirements were going to force them to engage in the take of rare, endangered, or special status species or the sedimentation of surface waters. The modification process gave them an opportunity to seek redress, to say, hey, I cannot do this thing you are telling me that I must do, as well as the alternate means and measures request that allowed them to come up with a way to achieve the same substantial effect. And I think what is important here, though, is to recognize that you are not required as a public agency to account for everything every private parcel owner in your jurisdiction may do to comply. And that was really the basis of the redress the plaintiffs were seeking, that they felt that the public agency had to survey the entire landscape and had to develop a parcel by parcel mitigation plan in order to say we properly considered CEQA and cumulative effects. And as the judge determined, that was not in fact required. And I think what is so important there is that's not possible. It would not be possible for an agency to survey every parcel, some of whom may object to being surveyed, and then laboriously develop a parcel by parcel mitigation plan that may or may not be, they may or may not choose to use, because you couldn't require parcel holders to carry out the plan you directed. You can only require that they achieve the end state that's enshrined in your ordinance. You cannot tell them what they must do to get there. You can tell them what they can't do, right, through the regulatory process, but you can't tell them what they must do. And to me, this was a critical step in clarifying CEQA, and in the conversation with our elected board, who were concerned about both the cost and whether or not we would prevail, our discussion was, look, we have to hold the line on this issue, because if we do not, if we say that we are not able to consider cumulative effect, we are giving up on any attempt to require defensible space beyond either 30 or 100 feet from a structure. And based on the conditions in our fire district, while we think the defensible space and home hardening elements are very important, they are complementary and require this additional work to compartmentalize the landscape to give our firefighters a reasonable chance of containing these fires and limiting the number of structures that experience unprotected exposure to wildfire emanating off those large private parcels.
Yeah, and the reason that question of cumulative impacts came into play is that that's one of the exceptions to categorical exemptions, is that if a project that's normally exempt would, if it is part of a series of smaller projects that when combined could create a significant cumulative effect, you are not supposed to be able to use the exemption. And as we'll talk about, part of why we prevailed in that case was that we developed evidence to support the conclusion that that was not actually going to be the result of this program. So next slide, please. So this is where I talk about best practices, and they apply broadly, but we're talking primarily about exemptions. But one thing people don't necessarily know about CEQA litigation is that the court is not looking at whether what the agency did was right or wrong. For the most part, what the court is looking at is whether or not the agency abused its discretion. So did the agency go beyond a proper exercise of discretion based upon the evidence before the agency at the time that it made the decision? So from an evidentiary standpoint, what that means is that CEQA cases are based on an administrative record that is essentially the files of the city, county, or agency at the time that their elected body decides yes or no, at the time of the vote. And it stops at that point. So CEQA isn't a civil trial where you have witnesses and discovery and you trade documents. It's basically, what did they know at the time, and was that adequate? Does that support the decision that they made? This is particularly important in the context of exemptions, because often agencies think, well, it's exempt, I don't have to do anything, right? That's the idea, that it's exempt, so I have to just declare it exempt and that should be enough. And that's absolutely not the case. Your record is as important on an exemption as it is in any other type of CEQA case, and you don't have a lot of opportunity to make it. So before you decide to rely on an exemption, you need to look at the criteria for the exemption. What does it actually require? What types of projects does it say will apply or will fall within it? And you need to do your homework as an agency to show why your project fits within that exemption. If you're relying on a categorical exemption, you also need to make your record on why the exceptions to the exemption do not apply. So you need to say, we've looked at the question of whether there are significant cumulative effects, and here's why there aren't. We've looked to see if there are historic resources, and we have evidence to support the conclusion that those exceptions don't apply. And that was really the key thing that we did in the Moraga-Orinda Fire District litigation. For example, as Dave said, the opponents were talking a lot about, well, nobody's going to understand this guidance. They're going to clear cut. They're going to clear cut their yards. And when that happens, there will be landslides or there will be habitat destruction. But the agency had gone to great lengths to show, no, we're really telling people how to do this. There are resources online. We're sending out mailers. There are detailed instructions. And if they think there is an effect, like a protected species, they can go through this workaround and they can tell us that, and we'll work with them to address their specific circumstance. And the court found that that was substantial evidence in favor of the agency that this would not have a significant effect on the environment. That, you can't account, as Dave said, for anything someone might do to comply, but most people are going to act reasonably, they're going to read, they're going to understand, and they're going to do the right thing and implement this in a way that these resources tell them to. Sometimes applying an exemption requires technical work from a consulting team. If, for example, you want to have some biological evidence to support that an exception doesn't apply, and that might be counterintuitive, right? Because you're not doing an EIR, you're not getting a consultant on board to do a major contract, but it's thinking about what you would need to demonstrate to show that your project falls within this exemption, and then building up evidence to support that conclusion. Really the key to success in these circumstances, as with any CEQA case, but particularly on exemptions. And then the last best practice is just file your notice of exemption right away. One of the nice things about CEQA is it has a short statute of limitations. So anyone that wants to come out of the woodwork to oppose your project has to move pretty quickly. It's 30 days for an EIR or a negative declaration and 35 for an exemption, just because CEQA wants to be confusing in every possible way. But point being, it's a fairly brief period. So get those notices on file so that you know pretty quickly if you have opposition. Someone has to act quickly if they actually want to file a judicial action. So that's my best advice. Happy to answer any questions. And I think that's my last slide, Dave, but let's double check that we don't have one more.
And I would emphasize on the technical on the record. That record is closed when the agency takes action. In this case, that was when the agency adopted the ordinance. So that included a technical memo that I wrote and presented to the fire board, but it was informed by the experts and the consultants that we had retained to ensure that all of our I's were dotted and T's were crossed. And it included an almost 1 hour presentation to the board that laid out all of the things that we considered and therefore that we wanted considered if this went to litigation. And that ended up being critical because if you have not done that, it does not matter what you were thinking and what your intent was and what you were going to do. If you didn't write it, if you didn't present it, if it wasn't part of the public record that was available at the time the legislative body took action, it is not part of the case going forward.
Yep, absolutely. You cannot develop that evidence after the fact. So you have to make sure you get it in before that deadline. So I actually do have a couple more slides. So I want to talk about the Cal VTP, which is the California Vegetation Treatment Program. Folks may generally be familiar with this, but it's essentially a large-scale, statewide, multifaceted strategy to address California's wildfire crisis. Includes all different types of treatments, and was intended to, among other things, provide the ability for local agencies to tier off of the EIR for that document. So essentially, they did a program EIR, and as a local government, if you are implementing work that was studied in that EIR and falls within the impact footprint of their project, you could then do a less sort of onerous CEQA review by relying on the analysis in that document, which I think is really an excellent way for our state to approach these types of things, to have something at the state level that local agencies can then rely upon. Now, of course, this was litigated. The next slide will tell you a little bit about what happened in that litigation. The document was upheld for the most part, but found invalid on one issue. And it was essentially the idea that if chaparral was cleared, and it's type conversion, I think is the term, right?
Yes.
That something else might grow back. So essentially, you're not going to get the same native plants coming in, that if you are clearing these areas, other things might come. I don't know that much about the science of it, but that was the allegation. And the court ultimately found the EIR did not adequately address that question. However, it did not overturn the entire EIR. If you've been part of CEQA litigation, you might know that often the whole EIR is thrown out the window and you start over. But courts do have the ability to sever certain issues. And so this document remains valid for a wide variety of types of projects, but it may not be used for proposed treatments in chaparral or coastal sage scrub, with certain exceptions that you can find at this link. And you know, the process to redo this EIR is just getting started. They issued a notice of preparation that didn't say the right things. They just reissued a new notice of preparation this month. It's going to take some time for them to go back and address this. And my guess is there will be additional litigation challenging how they decide to comply. But it does offer a pretty nice tool for folks to say, hey, is my local project within what was analyzed in this EIR? And if so, can I do a CEQA addendum? Can I do a limited scope negative declaration? Can I do an exemption? Can I do something that relies on that analysis? It's just one of the tools in the toolbox with that EIR. And stay tuned for how the revisions will go forward.
And just one note, though, I've seen this with a number of local agencies who are told, well, that area is in the Cal VTP and therefore you're good to go. It's either an SRA or LRA very high. Of note, an area that was covered by the Cal VTP, you still need to do a project-specific analysis, or PSA, has to be done for your project under the Cal VTP, and then you need to make a determination about filing a negative declaration or notice of exemption. You still have to do all of that work, as well as the SPRs, or standard project requirements. All of that still needs to be done and filed. And so it is a streamlined process, and you're able to benefit from this statewide EIR that was conducted. But it isn't just green light go, that these are areas in which you can do work. And there are definitely restrictions that are site specific that have to be considered. So it is more than just you're within the VTP and you're good to go. It's still a reasonably significant lift to do work in these areas.
Yeah, that absolutely. And I think what it saves you is it can save you some of the work on analyzing impacts under certain conditions, but you would still need to show why your particular project does actually reflect what was analyzed in that document. So you're still going to need a consulting team to look at the specific physical conditions of your project. But it certainly can be a less onerous undertaking than doing a project level EIR if you have the right type of project. So next slide. Other options for CEQA compliance, of course, if you can't use an exemption or tier off of the Cal VTP, an EIR or a negative declaration is absolutely an option and is doable. Try to design your project to avoid impacts that are likely to trigger opposition. That's just good advice in general, and that's really what CEQA was supposed to do in the first instance, right? Is try to help us design projects that have less of an environmental effect. And then make sure you have the right team. Most importantly, a CEQA consultant with the right experience. There are some fantastic consulting teams out there who have done a lot of work in, on fire projects, on wildfire risk reduction projects in particular. Making sure you have that right quarterback at the helm to kind of guide your CEQA compliance is really important. But it's, to Dave's original comments, CEQA can be burdensome. It's nothing to be afraid of. Yes, litigation, it's difficult to give good odds. You can't bulletproof a CEQA document, but you can do a lot of things to improve your chances of prevailing and really maximize your chances of success in the process.
And so I'll editorialize briefly, which is the designing your project and the second one be triggering opposition. So it is really a good idea to have some conversations with folks that are involved in this space. To the point about the Pearson litigation, one of the items in a suburban setting that we were concerned about was dead trees. That would seem like something that reasonable people could agree that with regard to wildfire, dead trees are problematic. One, they are very difficult to extinguish once they begin to burn. Because of their configuration, a standing dead tree, if fire gets into that dead tree, they're prolific producers of firebrands and embers and can sustain firebrand or ember production for hours. Really problematic. Unbeknownst to us, and to be clear, I was a firefighter. I walked into environmental compliance via the firefighting door. And so what I thought was reasonably easy for people to agree upon, the dead trees are bad. Well, in this case, the plaintiff felt that, believes that, or perhaps this is true, I'm not in a position to adjudicate it, but that dead trees were also could be granary trees that were critical to sustaining the food supply for some types of animals during the winter months. And so that just being an example of the sort of thing that you would probably never encounter that on your own, especially if you're coming at this from a public agency and not a resource management public agency perspective. And it just speaks to the importance of engaging with folks that could form the opposition to understand what their concerns are and then filter through those concerns so that you understand what are the things that potentially are going to be impactful from their perspective, and then essentially divide that by the value of the project. And so there are areas and times where doing work in environmentally sensitive areas are justified because the impact and the benefit to the community is so great. There are other times, I would refer to these as lazy acres when it comes to fuel mitigation, where that work is going to have no demonstrable benefit to reducing the risk of to the community. And if that also then overlays on an area that is of great concern, that's a very good idea, good reason not to do that particular piece of the project. So design the project to get the maximum benefit with the minimum impact to the environment, and minimum impact to the environment partially viewed through the lens of the concerns that some folks may have about something that wouldn't have been intuitive to you as a public agency with regard to what represents environmental concern. Doesn't mean that you're bound by it. Having the conversation isn't an agreement, but it's a very good idea to understand what people's concerns are and prepare your project accordingly. All right, so next we'll talk about a little bit about this. We talked about this previously, but we'll talk briefly about the about what cumulative effect means. So I would just point out here that if you have the authority for the prevention and suppression of fire, which either a municipal fire department or a fire protection district, either independent or dependent special district, has that authority. You are authorized, either through the California Constitution in the case of a municipal agency or the Fire Protection District Law of 1987 for special districts, to enact exterior hazard abatement ordinances or add provisions to the fire code. It's an agency-specific choice where these should reside, that meet or exceed the state standards, including Government Code 51182 for local responsibility areas and Public Resource Code 4291 in state responsibility areas. And put simply, those are the defensible space ordinances that are intended to create the conditions around structures that are not conducive to carrying rapidly spreading fire to the structure. So if a local agency chooses to enact local requirements that meet or exceed those state minimums, that can require residents to carry out activity to reduce the risk to their homes through vegetation management near the structure. Baseline CEQA exemption or Cat 4 is 30 feet from the structure. If, however, the local agency determines that the local conditions are particularly hazardous and require an extension of that fuel mitigation work out to 100 feet, to avail yourself of the Cat 4 exemption, you have to file an NOE citing with a substantial finding of fact, demonstrating why the additional separation is required, and that NOE needs to be filed. If you have not done that, defensible space work from 30 feet to 100 feet, zone 2, defensible space work, is outside Cat 4. And so then, as we addressed before, that there are concerns that could be raised by residents saying, well, you have to consider the cumulative effect of all of this work. And in this case, I think we were able to establish that with a well-prepared finding of fact and a well-prepared administrative record, we were able to show that cumulative effect was not a requirement that we had to consider on a parcel-by-parcel basis. And I think the key component to this is that, as Kathryn mentioned a minute ago, in that particular case, one of the things the plaintiffs were explicit about seeking was they were seeking to cause the fire district to act as an environmental regulator to prevent residents from carrying out work that may or may not have been less than beneficial for the environment, as was otherwise allowed on their private parcels, which is not something the fire district has the authority for. The fire district is not authorized to tell people what they cannot do. We can only tell them what cannot be there with regard to the prevention and suppression of fire, which is our mandate. And so if a resident were to choose to go do something in a riparian area, that's certainly a bad idea, and the fire district certainly wouldn't enforce it. And if we were to encounter that, we would share that information with the appropriate regulatory agency, but that's not something the fire district had the authority to enforce or to regulate. And that was one of the things the plaintiffs were seeking under cumulative effect. So just to be aware, you have the authority to establish wildfire mitigation measures up to 100 feet under Cat 4, and you have the authority to require other wildfire risk reduction activity under your exterior hazard abatement ordinances, but those things beyond 100 feet with the NOE are not generally covered by Cat 4 because they are greater than 100 feet from a structure. So the next thing then is what happens, and this was one of the central concerns that the plaintiffs raised, was what happens if a fire district or a fire department or a city says, residents must clear vegetation within 100 feet to these standards such that it will not be capable of readily transmitting fire. And in complying with that requirement, a resident is being forced to do something that would result in the take of endangered, rare, threatened plant or animal species or significant erosion and sedimentation of surface waters. And that clearly wouldn't be good. And a resident potentially could be caught between two regulatory agencies, one, the fire department, fire district, that is potentially on their parcel, citation in hand, using their administrative powers to require compliance. And then we would be forcing these people to break the law. This is an allegation that is regularly raised by opponents. And there's a very simple solution to that, which is in your ordinance or in your fire code, and certainly in any communication with residents with regard to compliance or to citations that would force compliance. It is critical that there be a provision for modifications, which is a longstanding section of the fire code that would allow a resident to avail themselves of an alternative approach if there are practical difficulties related to complying with either the fire code or the exterior hazard abatement ordinance. So a great example of that could be you require shrubs to be removed and to be separated. Well, a person with a large parcel with a hill covered with shrubs could say, well, that is, in the case of the Bay Area, that is Alameda whipsnake habitat. And Alameda whipsnake habitat, you cannot clear. So then we would say, okay, if you are seeking a modification, what alternative do you propose? And the resident could propose different ways to comply, one of which might be using the existing BMP, the best management practice, that allows for creating islands of shrubs using hand thinning in Alameda whipsnake core scrub habitat. So there is a mechanism to comply. And the mechanism in this case means following the BMP. And the language and the requirements of the BMP might not exactly match what is required in the exterior hazard abatement ordinance. And through the modification process, that would then allow a back and forth between the resident and the agency having jurisdiction to essentially to negotiate a solution that would achieve both wildfire risk reduction and preserve the protected habitat. So critically important that there is a modifications component included. If your exterior hazard abatement requirements are included in your fire code, there's no reason to do anything else because you already have the provisions for modifications in the fire code. If these are being adopted through standalone ordinances, critically important that the language from the fire code be lifted and brought across to the ordinance so residents have that same ability to avail themselves of relief if there are practical difficulties. And the second fire code component that's very helpful is that from a local agency perspective, at least certainly from my perspective as a fire chief, I did not care how we got to the end state of the same practical effect. If there was a better way to go about doing this work than was enshrined in the code and it had the same practical effect, I'm all in. No fight for me, happy to get there. And the code is simply one way of getting to that solution. And through AMMR's, alternate means and measures request, a resident can propose a different way to achieve the same practical effect, which could also, importantly, include their willingness to voluntarily undertake mitigations that you cannot otherwise require, such as some retrofits to the structure that could increase the resistance of the entire system, meaning that they can carry out less mitigation work on the vegetative front if they carried out some home hardening retrofits that would achieve a higher level of resistance. Same practical effect. So critically important that these two components are lifted from the fire code and brought across if you're doing this through a standalone ordinance, and that this information is communicated to residents so they're aware of it. This is an example from the MOFD website about how a resident can submit a request for modifications and explain exactly what they are concerned about. So I have this concern. If I clear this area, that will create soil instability to contribute to the sedimentation of surface waters. So, okay, no problem. What alternative do you propose? Are you willing to move the mitigations off the slope so that the slope is now, you simply move it around? Do we do a different approach where we thin, right? What exactly are the concerns with soil instability? Is there a geologist report verifying that? And how could we achieve the same practical effect? How can we stabilize that soil, yet also minimize its likelihood to readily transmit fire that could become destructive? Important at the bottom left there, This is not well understood. Recognize that residents typically, this will be the first time they've been involved in something like this, and you really want to make it easy for a resident to access this and also lead them to submitting all of the information, understanding that a AMMR modification is not generally saying I'm not going to have to do any work. It is that I am coming up with a different way to achieve the same practical effect. And that different way to achieve the same practical effect may be more onerous than simply carrying out what was originally required. But that's certainly not a call for the jurisdiction to make about what is the best way for this resident, for them, their circumstance to move forward. All right, so we'll talk briefly here about BMPs and effective mitigation activities. So one of the things that we did in preparing the administrative record and attempting in good faith to address the concerns that were raised by the residents in this particular case was that residents of the district would be told to go what needed to be done. They needed to reduce the density and the configuration of fuels so that it would not readily carry fire, and that they would just go out and uninformed by best management practices and by environmental considerations, that the fire district's exterior hazard abatement ordinances would precipitate a large-scale clear-cutting and bulldozing of the land. So working in this case with Sequoia Ecological Consulting as our technical experts, the fire district prepared a field guide to best management practices for environmental protection during wildfire risk reduction activities. And that included a number of different provisions and a lookup tool that allowed residents, and there's a link there in the bottom that will take you to the page where this information is available, but a lookup tool that allowed residents to understand what were the fuel types and the habitat type that was present on their parcel. And then they could cross-reference that to the guide to identify the BMPs that allowed or gave them very clear understanding of what best practices were, with understanding this varies by the area, by the fuel type, and what particular habitat it's in. And some of these BMPs include things like the requirement that work is only done with hand tools and you cannot use machinery. So the work still gets done, it's just done in a much more selective manner. Or work that is done in a manner that minimizes or eliminates soil disturbance. An example of that, if you're using machinery, would be using rubber tracked machinery instead of metal tracked, or keeping machinery off of steep slopes, or from a seasonal restriction standpoint, shutting down work during seasonal rains so that we weren't working on wet soil. There's also BMPs with regard to the percent of the fuel load cleared, right? So there, if you created clumps and islands where we separated fuel, there are certain cases where that is environmentally beneficial with regard to a habitat perspective, in that we are clearing out the overgrown decadent material that has encroached in the landscape due to the absence of the beneficial and normal fire return interval. So if we've excluded fire, we can introduce hand clearing and other mechanisms for clearing that create the same effect that a natural fire return interval would have. And then also what type of vegetation is cleared, and with an emphasis here on clearing invasives and either setting conditions for native plants that are present to thrive, or really just clearing out those natives so that we have a blank scape on which then you could either engage in reseeding or some selective replanting of native plants. Noting though that just because something is native doesn't mean that it is fire resistant. There are plants in fire dependent landscapes whose adaptation is to grow back more quickly, right? So we want to be very thoughtful about what type of plants we have in, and it's not just a blanket that invasives are bad and natives are good with regard to fire resistance. Maybe very true from an environmental standpoint, but not necessarily from a fire spread perspective. And then lastly, making sure that we understand the seasonal restrictions, things like nesting bird season, at times where we have particular plants or animals are vulnerable. In whipsnake, one of the examples is there are restrictions on doing work with either machinery or the use of fire in the fall and winter months because a reptile in a colder months are more sluggish. They're less able to slither to safety. And so you have to be more thoughtful about the type of work you're doing and include additional monitoring or additional BMPs to allow those animals time to warm up and to remove themselves from being inadvertently injured during the work. And then lastly, as a general statement, there's exceptions to every rule, of course, but as a general statement, any work that's done in a riparian area, and riparian area meaning a water course, a very simplistic view of a water course, if there is water in a space and you are pointing towards the water and your feet are pointing downhill, you are now probably in the water course. Highly sensitive, very restrictive environment, and generally not worth the effort to try to figure out the path that would allow you to do work in that area. Also, because there's water there, vegetation is generally better hydrated and less susceptible to carrying rapidly spreading fire. All right, so lastly, we'll just talk about how we choose our mitigations wisely. And I'd say to have thoughtful mitigations, we have to have a plan. And so a good place to start with the plan is always to understand what we're trying to accomplish. So what is our goal for our wildfire risk reduction plan? Our goal should not be to go do stuff and to generate activity. Our goal should be to meaningfully reduce the risk to our community. And I would offer up three things that could be considered. Certainly, this is not an exhaustive list. But the first was a goal could be increase the time required to initiate an urban fire. How long it will take fire to transition from being a vegetative fire to a structure fire. Increasing that time is a worthy goal and something we can plan towards. And we could then identify a plan and value mitigations relative to achieving that goal. Protecting critical evacuation routes either in their entirety or specific intersections, noting that we now have a new categorical exemption with the legislation passed this year, allowing work within 100 feet of the center line of a road. So we can protect roadsides and we can protect critical intersections that are critical hubs on our evacuation routes. We are authorized to do work using that exemption along those roadsides. Or protecting critical infrastructure or target hazards. An excellent example would be a water treatment facility, a sewage treatment facility, a hospital, a large board and care home, something along those lines, or schools perhaps. Critical infrastructure that if fire reached that area, you would have a very real problem on your hands. And having identified our goals and worked through a process to identify and to prioritize our goals, because we can't do everything everywhere, then build an achievable plan that matches mitigations to the mechanism of ignition. So we want our treatments. We want to look at where they're going to be. We're going to look at the prescription. To what degree are we going to modify the fuels? And what is the cost? What is the benefit? How do we prioritize those based on cost benefit? How do we cluster them to achieve network effects? And then being really realistic and pragmatic about our available resources. If there is a plan that involves treating 1,000 acres and getting 1,000 homes to carry out defensible space and home hardening, do you have the resources to reasonably achieve this plan? And if not, how can we break this into a series of work units where we could get the same network effects but on a smaller scale? So we don't end up with a shotgun blast of a little mitigation here, a little mitigation there, where fire will simply burn right around these isolated areas. We haven't been able to create that those non-burnable buffers that won't carry fire. And also with regard to work on the landscape, being very thoughtful about what the cost and the requirements are going to be for out-year maintenance and ensuring that the administrative record and the plan that we're building on the front end is incorporating future maintenance activities so that future work, and under the VTP, a PSA is a great example. The PSA for the initial entry can and should be written to allow for subsequent entries to maintain that work. So you're under the same CEQA coverage that you had from the beginning. And then lastly, if there's one point I would ask you to walk away from, it would be giving real thought to your measurement metrics, and that those metrics are tied to outcomes, as in measurable, quantifiable, demonstrable reductions in community risk to meet the goals outlined above, not just activity. If our primary measure of the work we were doing is how much money we spent, or even slightly marginally better, how many acres we treated, I think we're missing the point, right? We have spent an enormous amount of money over the last 10, 15 years on wildfire, yet we still continue to lose homes at large scale. And we've treated a lot of acres, but we've had fires, say, such as the Eaton fire, that started 800 meters from the community. No amount of ridgetop fuel breaks and distant landscape treatments that have benefit in their own right, but no amount of those could have protected that community from fire making its transition. And we put all of that together. Let's attempt to shift screens here. When we put all that together, we can come up with a plan that recognizes what the risk is and how that risk can be mitigated by looking at what are the mechanisms of ignition. What is the manner in which a particular home is ignited? And once we understand that mechanism through which a particular home is ignited, we can then start to understand what the what the mitigations are that we can use to match the mechanism of ignition to the mitigation so that our work is efficiently allocated across the landscape. And so, as an example of that, we have a community here that has an exposure to wildfire, orange being an ignition, green being structure to structure fire spread, or sorry, vegetation to vegetation fire spread, blue being embers that have now jumped a road or something like that, and red being subsequent structure to structure ignition. And as we can look at the mechanism of ignition, where it is vegetation igniting a home, that home needs protection against ground component fire, so defensible space. It also needs protection from embers. Where it is embers, but not vegetation fire that is igniting a home, that home needs ember resistance, a Class A roof, ember resistant vents, and zone zero work. And where it is a structure igniting another structure, that mitigation probably is let's pull the work upstream and let's look at where there are opportunities to protect other homes. So here we see red is homes that need defensible space and home hardening. Blue is homes that need ember resistance, and purple are homes that have a risk of urban fire, but that mitigation is upstream work so that fire never gets into the homes and could allow fire to spread through the area. And if we combine that with a thoughtful vegetation management plan that does things like protect the critical intersections and evacuation routes that get people out, that builds a buffer at the vegetative edge so that we are less likely to see fire transitioning from the landscape into the community by building areas that will resist the spread of fire across the road, this non-burnable buffer that separates the community. And if we can combine all of those into a combined, comprehensive, integrated plan with defensible space and home hardening work at those homes that are subjected to ground component fire, ember resistant at those homes that are within the ember deposition zone, and thoughtful fuel treatments along critical areas that augment and reinforce this work being done on and around homes, we can move forward to a mitigated future in which fire has a very difficult time becoming established in the urban environment. And having a plan like that, having an understanding of how fire will spread and a mitigation plan that matches it could allow us to engage in a really detailed discussion about whether or not a particular treatment area is worth it and what that treatment is going to buy us for our path ahead. So we'll wrap up there with the presentation. I think we have time for a few questions. Melissa, I turn it over to you if there's any that came in live, or we can go with some of the ones that were pre-submitted.
Yeah, perfect. Thank you so much for the presentation. As we mentioned, we have been tracking your questions, and so if you have anything else that's coming up, please feel free to drop them in. We'll get to as many as we can. But I'm going to start with something I've seen a couple of questions come in on, and Kathryn, I know you covered this a little bit, so maybe you can just expand on CEQA considerations for work in chaparral ecosystems in light of the Cal VTP ruling. Specifically, there's a question around project-specific analysis and if that's enough in that instance.
So I think it depends on the scope of your project. Every lawyer's favorite answer, right? It depends. I think, you just expressly cannot rely upon that program EIR for work in those specific circumstances. And there are some exceptions to that. But if that was one part of a larger project, you might be able to take some of the tier for part of your project off of the program EIR and then do sort of project level analysis for the areas that aren't covered by the Cal VTP. I do think if your project is primarily work in that type of ecosystem, you might be better off just doing an independent document, your own analysis, which is always an option, right? You're never required to tier off of the Cal VTP EIR. It's a tool. But if it's simpler for you to simply go forward with your project level analysis, you can do that too. And hopefully we will have a remedy on that EIR here, reasonably soon, within a year, right? They've started work on that. And everything with CEQA really comes down to the science, right? What CEQA really wants to understand is the impacts of your project. And so whether you're relying on project-specific analysis on the CalVTP document or whether you're doing your own EIR or negative declaration, you just need to have substantial evidence to support the conclusions in your EIR about environmental effects, right? And so that means underlying technical work regardless of the legal strategy.
Thank you so much. Um, I have a feeling the answer to this one may also be it depends, but I want to ask in case there's any overarching guidance. Um, if is there any rule of thumb in terms of how long CEQA exemptions would be good for? So had a jurisdiction or a region had a wildfire, um, and is going through recovery efforts, is there any kind of standard on how long that those CEQA exemptions related to recovery building would be for? If that was
Yeah,
not
so I
too
think, yeah, so I
convoluted
think
of a question.
no. I think what you're referring to is the executive order sort of post Palisades exemptions for rebuilding, which is a little bit outside the scope of what we're talking about today. And no, I mean, there's nothing about that circumstance that's really typical, and hopefully it never happens again. I mean, that's sort of the goal of all of this, right? But no, I don't think there's any clear expectation on how long that ability to rebuild with less green tape will last. I don't know. Dave might have comment on that. I don't know if you have insight from your policy dealings.
I don't. I think it depends. And the question really has to do, they're powerful forces at work here on both sides. There's desire to get folks back into their homes. There's also desire to get sort of the normal administrative operations back into effect as well. I don't know how long they'll be in effect. I do know though that any exemption, particularly an open exemption to CEQA, that is intended to be temporary, is heavily scrutinized. Because folks who are concerned about a weakening of CEQA say, well, if we want to create this exemption, we shouldn't do it through emergency powers, and those come under a great deal of scrutiny. And to note, of course, as I understand it, those exemptions are specific to rebuilding, and that they do not exempt or waive landscape level treatments. I was involved. We were one of the 35 priority projects back in 2019 for the North Orinda Shaded Fuel Break, and that came with a CEQA exemption. But of note, a CEQA exemption is not a NEPA exemption. And there were federally protected species in the project area. And so while we didn't have to do a full EIR, we still had to integrate the BMPs and the monitoring associated with protecting those species because there is no state ability to waive federal protections as well.
Yeah, and I'll just note in that vein, I mean, the reason we're talking so much about biology and the challenges that biological concerns present is that the Endangered Species Acts are very powerful laws. It is without exception illegal to take an endangered species, and take means, kill, harass, chase. I read all those things. There's different definition under federal law than state law, but under federal law, habitat modification is considered take. And so this all comes back to how you design your project, because once you are engaged on a project that will, involve habitat modification and you're looking to take permission from, a federal agency, from, the service, that takes a long time. And mitigation for those impacts is incredibly expensive and onerous. And so if there is a way to avoid that, it is absolutely the way to go, because they're difficult processes, and frankly, more difficult right now potentially than ever, given the state of the federal government and staffing issues and those types of things. So avoid the Endangered Species Act if you can. That's probably the most concrete advice I'll give you today.
No, but also definitely a good flag on the distinction between what we're doing here in California and CEQA regulations versus that doesn't override anything that NEPA outlines. And so making sure that agencies, while you may have gone through CEQA exemptions, make sure that you're also checking all of that with any federal requirements.
Yeah.
Dave, a couple of questions came in on the example you shared at the end of your presentation, um, including how would a city or a local agency engage with a vegetation mitigation plan? So, for example, the one that you showed for the Portland Forest Park.
Yeah, carefully. So starting with an understanding of what we're attempting to achieve. Where are the areas where mitigation, we're not going to treat everything everywhere. So where are the areas that act as nodes that have particular impact, either a high degree of centrality or tendency to make hub, that are likely to propagate lots of fire? Or where are there areas that if fire reaches this point, i.e. those critical intersections, we have a very real problem. If there's one way for everyone to get out and that area is impacted by fire, we're now out of way to get residents out, firefighters in. So we have to protect that intersection. So let's start with an understanding of our goal, and then let's match the mitigations to achieve the goal. That's the starting point. But that is far from the end point. The next step is to figure out land ownership. Who owns that land? And do we have a path forward to carrying out the work? Next would be conduct environmental review. Are there special status species or potential for soil instability in those areas? So we know which section of the book we're in with regard to how we would carry out the treatment. And then understanding the difficulty of carrying out treatment in that area, we can start to do a cost benefit to understand, is this one we have to have, and therefore we will bear any cost to do particularly hard work? Or is this an area that is of marginal importance, and the increased cost associated with either the presence of special status species or the potential for soil instability cause us to pull off that area and look for somewhere else we can do the work? Understanding that we will never have enough resources, never enough time, money, staff capacity. And so we need to prioritize the work to where it'll have the greatest benefit, but that greatest benefit is offset by the cost. And environmental considerations part of the cost. There's also, the question of land ownership. I refer to that as the human terrain that you have to analyze. If there's a private property owner who is not willing to participate, this is gonna be slow go, especially if you don't otherwise have a requirement that they would have to carry out this work. It can be equally slow go if it's a landowning public agency within your jurisdiction that has their own plan, their own prioritization, and may have their own approved wildfire risk reduction plan that went through an EIR, and that they are loath to deviate from, because that was a series of probably years-long negotiations with a bunch of involved people. And those negotiations may have happened 20, 30 years ago when we were thinking less about urban fire spread and more about damage to the landscape and to the environment. And not to say that we shouldn't be concerned about damage to the landscape environment, but that's often a very different approach than would be taken to protect communities. And so we need to balance those things out. So we examine the human terrain, figure out where we have support or supportive folks, and then all of that goes into the review about the cost, the benefit, the likelihood of success. And then lastly is, what are the resources available? If we have thousands of acres worth of work that we would like to do, and we have hundreds of acres worth of resources that we can convert essentially, well, let's not undertake this massive plan that will exceed our ability to carry it out. And I would say similar idea, if we're relying on grant funds, which is nothing wrong with that, we just got to make sure we've considered maintenance, because stuff will regrow. There was a question in the chat about if one goes and carries out a thinning or a removal project in chaparral or southern coastal scrub, and that grows back as invasive species or grass, which was the subject of the recent lawsuit, it is far from clear that that was a benefit to the community, because fire is likely to travel faster through that unmitigated space or that unmaintained space where invasive species have grown back, right? So now we caused environmental damage and we didn't achieve our outcome. And that's what the judge found. So we want to be very thoughtful about how we're going to maintain things, and that over time we may find that all of those things are simply too much. It's a bridge too far to carry out work at scale. And then I would argue that if we have four domains of wildfire risk reduction, and those are landscape treatments, defensible space, i.e. vegetation management within 100 feet of a structure, maybe 200 under the new legislation, home hardening, which is retrofits to make the home more resistive to ignition, which can be required for new construction or major remodels, but cannot be required retroactively as a one-off, and firefighting response, which is our our fourth domain. We have over-indexed on the landscape treatments and on the firefighting response, meaning there is an enormous amount of opportunity present on and around structures where we have environmental clearance. We have a green light under Cat 4 to carry out work in those spaces, and we have not done very much of it. So there's an opportunity to rethink our approach. And I think one of the factors that should go into that consideration is the cost, inclusive of environmental review and monitoring and maintenance in out years. We should consider that cost when we're coming up with our prioritization.
So start with your end goal in mind and work backwards from there. But I think it's a really good point about the grant funding component as well. A lot of agencies obviously are looking for grant funding to do work in this space, but if that funding sunsets in 18 months or 2 years or 3 years, what happens? What happens then? And how do you continue to mitigate in those spaces? Um, we have time
And the
for maybe.
landscape is littered with old fuel projects, fuel breaks, et cetera, that were not maintained. Some of which, in the case of ridge-top fuel breaks, particularly in Southern California, are now grass fire spread highways that will move rapidly moving fire along them in a way that exceeds the spread rates we probably would have seen under the native conditions.
Looking at time, we probably have time for one, maybe two more questions. Um, Want to circle back to something that we've heard in other installments of this series, Dave, and I think related to the conversation we were just having around how can local agencies engage in this space. What can jurisdictions do to expand Zone Zero?
Well, expand or implement. I mean,
Both. I would assume the question says expand, but
yeah. I mean, I don't think there's a case for expanding the measurement. Certainly, there's a very strong case for expanding the implementation. And I think the best way to go about that is really having an honest and transparent conversation with the community around the effectiveness and the cost of any other approach. In my time as a fire chief, what I heard an awful lot of was residents explaining to me with great certainty why someone else should be doing something to reduce their exposure to wildfire risk. And if our goal is to protect homes, the most efficient and effective, both from fire spread and from heat transfer and from a regulatory environment with regard to CEQA, the most effective way to protect homes is to protect homes. Anything that we do that is not on and around the home is going to be much less effective with regard to protecting those homes. And so understanding how fire gets into a community and understanding the value of aggregated mitigations, both on the landscape, in the yard, and immediately on and around the home, I think is an excellent beginning to the conversation around how Zone Zero, noting that Zone Zero does not require the removal of mature trees in essentially all circumstances, how that can be effective and how we can trade then the impact on the environment and the costs that are associated with things that have an impact on the environment with the protection of homes. And once we start weighing cost benefit, the cost to implement benefit of carrying out this work, and we start looking at it at scale, I think, at least to me, it makes a very, very strong case for implementing Zone Zero because any alternative would require pushing back vegetation capable of transmitting fire so far from the homes so that you got beyond the ember deposition zone. That would be extraordinarily costly and extraordinarily difficult to carry out in an environment where this type of activity is regulated, and environmental considerations are one of the things we're looking at.
perfect. Thank you. Let's see here. So that question just come in around, and this may be a little bit beyond the scope of what we're talking about here, but there's a CEQA connection that the attendee is raising in terms of wildfire evacuation plans. Um, so the question is around how CEQA is asking agencies to look at emergency evacuations, but anything else that agencies should be considering as it relates to evacuation planning. Dave, I think you mentioned this a little bit in terms of that, again, starting with end goals, thinking about property ownership, jurisdictional boundaries, et cetera. But anything else either of you could share in terms of planning evacuation routes?
Yeah, I'd briefly say for evacuation, there's two factors. One is the capacity, how many people are able to flow out, and the other is how many people. And when the people exceed the capacity of a road, that's a function of time. The road is adequate for the population under normal circumstances because everybody's not trying to leave at the same time. And so while we cannot necessarily increase the capacity of the road, widening, improving, et cetera, we can increase the time that is available. And we increase that time if our mitigation plan is built around slowing fire spread, so it takes longer for fire to get to the edge of the community, and then hardening the edge of the community such that it is resistant to fire spreading from the landscape into homes. We can that can increase our street capacity by increasing the amount of time that we're likely to have. Then the second component is the one about protecting the evacuation infrastructure. That if there is a road or an intersection or both that are critical to your evacuation plans, one of an approach could, from an agency perspective, could involve prioritizing roadside mitigation such that you keep the fire away from the road because all of your evacuation problems get worse if you have more people, i.e. rapidly spreading fire, who need to get out, and you have impacts to the surface street capacity by direct flame impingement because there's roadside ignitions.
Mhm.
And I'll just add from the legal perspective, I mean, and this is why we can't always give great odds in CEQA litigation, is that right now how to do an adequate wildfire evacuation analysis is a big question mark. We have court cases telling us what not, what not to do, but not much telling us what works. And the guidance we got out of the Attorney General's office a few years ago said you need to do this and you need to quantify increases in evacuation time, but we don't have great models for doing that. So, as in all things CEQA, to do a defensible analysis, you need to build your evidence. You need to have the experts with the right letters after their names who can reliably predict these things and do the best you can with the data that you have. But it is definitely a hot issue and a kind of a problematic issue in CEQA right now.
Oh, perfect. Thank you for that consideration and that context. So we are at time, unfortunately. I know we didn't get to all of the questions, but I'll share contact information with you all in just a second. But just want to share quickly, obviously, also please feel free to join ILG's network of cities and counties and special districts, our newsletter, our social media channels, where we will share information on this topic and others and upcoming training opportunities. As we mentioned at the beginning, we have been recording, and that recording, along with the slides, will be available shortly. We'll send that out to you all via email. And then I want to share contact information because, again, I know we didn't get to all of the questions that came into the queue. So just want to say thank you to our panelists, Dave, Kathryn. And if you have any final thoughts to share before we let everybody go for their afternoon, welcome any final thoughts or considerations from both of you.
Nothing, just thanks for having me. This was great.
Yeah, thank you for having me. I just say there are paths forward in all of this stuff, and as with anything else, there are people who are very good at it, and this is not a space where going to self-educate is usually worth your time. That was certainly my experience, and how I came to know Kathryn so well. Was we needed an expert, she was one, and all of a sudden we were in good hands. So I'd offer this isn't a monolithic, scary thing. There are people who know how to do it.
Perfect. Well, thank you again, both of you, so much for sharing your expertise with us this afternoon, and thank you to everybody on the line for joining us for an extended lunch hour to talk about this important topic. And we will share the link to this and all of the other sessions in this series with you shortly. So thank you, and have a great afternoon.